Hello viewers, this is Advocate Aashi Pawar, Deputy Vice President Legal Services at NRI Legal Services. Here we are with our another Ask Me Anything session. I warmly welcome you all. So today's topic is claim your assets in India. So in this session, I will talk about how you are going to manage your properties in India, have a control on your assets in India sitting abroad. So if you have any queries related to this topic, you are free to jump in and post your queries in our comment section. We will try our best to answer each and every query during this session. But if any query is left unanswered, don't get disappointed. We will get back to you on that. Before we begin, I would like my colleague to introduce herself.
Hello everyone, my name is Advocate Akriti Singh, Senior Legal Associate, and today we are going to discuss this topic, and let's begin our session.
Yes, so let's start with the introduction. So non-resident Indians are often maintaining properties in India, residential, commercial, agricultural properties in India. But when it comes to managing all these properties in India, the issues are very complex. You need to follow certain legal and administrative requirements. So in this session, I will talk about all the steps and the procedures that you need to follow in order to legally claim your assets in India. So first of all, let's understand what kind of assets that can be owned and claimed by the non-resident Indians. There can be residential properties, agricultural properties, commercial properties. I have spoken about it in my previous videos as well, that the NRIs are not allowed to purchase the agricultural properties as they are prohibited under the FEMA guidelines. But yes, they can inherit the agricultural land from their ancestors. There is no bar on that. Speaking about the ancestors, if we talk about the ancestral properties, so while claiming your property through ancestors, you need to look into many factors. There is family dynamics, there are multiple complexities, succession laws, the chart of legal heirs, everything you have to take into consideration. So now I will talk about the steps that NRIs need to follow in order to claim your assets in India. So verifying and proving your ownership is the first step for the NRIs to claim your real estate in India. So it involves, you should have the title documentation with you, all other property related documents with you. Make sure that your property is free from any kind of illegal encroachment or any dispute, any legal dispute, right? So after verifying and proving your ownership in India, on your properties, your second step should be updating your property records. So what do we mean by this? You need to update your property documentation by way of looking into the rules and regulations of that state. You need to ensure that you have the required approvals and certificates and everything related to that property. You should have it in an updated form. So in order to complete this documentation, you need to approach the revenue authorities and time and again, because it is a little lengthy procedure, but yes, doing this thing, you can complete your procedure.
Through a power of attorney holder, NRIs, non-resident Indians, can designate a reliable agent to act on their behalf. Especially when there are situations involving real estate transaction, such designated person can act on behalf of NRIs so that they can represent themselves in the courts, revenue departments, and for any other real estate disputes.
When we talk about the inherited properties, when we claim inherited properties, there are two ways we can claim them. First is by way of will and then natural succession. If there is a will, what NRI should do? He should get it executed as soon as possible. But if there is no will in the picture, what you have to do is you have to approach the concerned court and obtain the letter of administration or succession certificate to get that required declaration from the court that you are entitled for claiming the deceased assets. So for non-resident Indians, claiming the assets also mean paying taxes, right? So you need to ensure that your taxes are paid for that property. It involves property taxes, rental taxes. Then you have to make sure that your income tax returns are filed on time. So in order to make sure that yes, you have everything in place and you are following all the tax regulations prevalent here in your state, you can take advice of any of the tax experts.
It is very important to obtain legal advice from real estate and property law experts so that you have proper knowledge of executing such documents. It becomes very crucial when you are an NRI. If you seek such guidance, it becomes a very invaluable advice for you in order to proceed further, because generally NRIs do have a lot of unclaimed assets such as their bank deposits, insurance policies, their mutual funds. So if you need to claim these assets or any movable assets, you need to seek advice of the experts. And it is also very important to take information, the updated information from the concerned banks and institutions, so that you are updated about the amount lying in the current banks where you have your immovable or movable assets.
So it is often seen that even if you follow all the preventive measures and you follow all the procedures, you still end up in a legal battle. So for NRIs, it is very crucial to resolve such disputes. How can you resolve such disputes? You can file a case, you can contest a case if any case is filed against you. You can approach the opposite party for amicable settlement. If the dispute is between the family, you can approach the opposite party for execution of family settlement agreements. So this is how you can, conclude and resolve your family disputes, property disputes.
Especially NRIs can sell their properties or their share in the properties, because when we talk about their share in the properties, if you see your long-term goal, you can definitely sell your share to other family members, but it needs to be ascertained that all the important legal paperwork is completed and the state protocols and the norms involving all these transfers and transactions should be completed, so that you do a hassle-free and a proper transaction with the other family members.
Akriti, we are talking and talking only. People are posting questions.
Yes.
I think we should start taking up the questions.
Absolutely. So we have question from Iknoor Sandhu. Hello NRI Legal Services. I have a question to ask. My grandmother is 85 years old and she lives in a house in Bhatinda. She wants to give this house to me. So thank you for your question, Iknoor. So definitely your grandmother can give this house to you. It is important to note that whenever a gift deed is executed, a stamp duty is applicable upon the same based upon the value of the property. But since it's a gift deed and it is being executed between a blood relative, so there shall not be any tax upon the same. On the other hand, you may also opt for a transfer deed in Punjab, and in that case there will not be any sort of stamp duty upon the same, and in your case I believe transfer deed is a more feasible option. So that is the case. And we'll take up the another question now. Ashok Kumar, please suggest, before I take up this question, I would like to add on something to the previous question, that in just additional advice that your grandmother can also opt for a will.
Yes.
So after her death, the same can be executed and the property can be transferred in your name without any applicability of any stamp duty or any other miscellaneous cost. Absolutely. So now we have another question from
Ashok Kumar.
Yes, it was from Ashok Kumar. And wait. Yes. Please suggest to me what is the best way I can get this house in my name so that my taxes can be as low as possible. Best way I can get this house. It's not specifically mentioned.
Okay.
So the question seems little incomplete.
Yeah.
So that my taxes can be as low as possible.
I think, Ashok Kumar, we are not completely getting your question, but yes, if you want any property to be transferred in your name, if it is in blood relation, obviously I think Akriti has told you that you can get the property transferred in your name via transfer deed. So this is the I think the main thing that you should follow. I think the transfer deed is the best thing you can proceed further with.
Absolutely.
Yeah.
So we'll take up another question from Miss Anju. How can NRIs ensure the physical maintenance and security of their immovable assets in India from abroad?
I'll take this. There are various ways you can do this. First of all is giving a power of attorney to some trusted person who can pay regular visits to your property or look after the daily affairs of your property. He can do that. You can appoint a caretaker also for that purpose. You can execute a caretaker agreement and that person will be responsible for looking after your property. Another way is you can install the CCTV cameras all around your property to have a watch on it 24/7. You can put a board on your property, in front of your property, that this property belongs to you. Or if your property is available, the data and the status of the property is available on any of the government website, keep checking that website only, so that you are very much sure that your property is always reflecting under your name. So I think these are the only measures you can take to safeguard your property.
We have another query from Mr. Ashwini Kumar. Madam, there is a family dispute going on between my father and my uncles related to the properties of my nanny. My father is not keeping well and want him to be engaged in unnecessary litigation. I don't want him to go to the courts and get depressed with all these situations. Is there any possibility I can resolve the case on my own without my father's involvement?
The dispute is between the father and the uncles. So thank you for your question, Ashwini. The thing is, the dispute is between your uncle and your father. So obviously, without your father's involvement or interference, you cannot resolve this dispute. It is not possible. But I understand your feelings. You are saying that you don't want your father to be unnecessarily dragged into the litigation. That's completely fine. What you need to do is you need to approach the opposite party, who are your relatives only. Approach the opposite party and start giving the offer of amicably settling the dispute out of the court, not going to the courts, and just settling the dispute out of the court. If they agree to the terms and conditions put forward by you, then obviously a family settlement agreement or any compromise deed can be executed between your father and the uncles. Your father will be the signatory to that document. My piece of advice for you would be, because you are willing to settle this dispute, you should make sure that your father's interest is not compromised at all. I mean, you need to do your homework first. Just analyze every factor that your father is not into any loss. If you think that your father is getting some benefit by executing the family settlement agreement, please proceed with it.
We have another question which states that from Mr. Malik. I'll just check. It was a similar question. I think we have already answered. Now we have a question from Mr. Sameer. What is the significance of updating property documents for NRIs? So it's a very good question. Thank you for your question. It is very, very crucial, especially for NRIs, to have up-to-date records so that the current owners are properly reflected on the records of the department. So to ensure this, generally it can be done through a power of attorney holder, because sometimes they do ask for presence of the party so that the records can be changed or amended as per the recent developments. However, you may also check these records on the official websites of the government so that you can see what all updations are there with regards to the ownership status of your property.
Aditi, I want to add something here.
Sure.
Whose question was it?
Mr. Sameer.
Okay, Sameer, I've spoken about this in my previous videos as well, how important it is to update your documents. I'll give you an example. So if you go to the government department and say that my father had this property in his name and now I want this property to be transferred in my name, and they check their records and they say that we don't find any document pertaining to this property in name of your father, what will you do? You are in deep mess. Why are you in this situation? Your father did not update the property records with the government departments, and then you will be at loss, right? So it is very, very important that you get all the property documents updated in your records, not only in your records but also in the government records, because when you are putting your property on sale or getting the property transferred in your name, both the documents, your documents and the government documents, have to be tallied, right? So it is very, very important. Never skip this part.
Absolutely right. We have another query. What are the advantages and disadvantages of appointing a caretaker? I have seen various cases where the caretaker only grabs the property. It gives a fear that delivering the possession is actually risky.
Whose question is
Am I
that?
right, Miss White? Ash.
Okay, so Miss White, thank you for your question. So mostly there are advantages only of appointing a caretaker. So when you appoint a caretaker in your property, obviously he is responsible for maintaining your property, looking after the daily affairs of your property, keeping it clean and livable for you. So a caretaker can also protect you from illegal claims from third parties, from any illegal encroachment. Caretaker can save a lot of time and energy of an NRI, because he is there always, and the society will identify that this property is under somebody's possession. So there are many advantages of a caretaker if you appoint one. There is just one disadvantage, and that would be they start overpowering the real owner of the property, taking this fact as an advantage that they are possessing the property. So to defeat this purpose, what you can do is just execute a caretaker agreement with your caretaker, and please specify all the terms and conditions, what are going to be the roles and responsibilities of this caretaker. So in case in future if you end up in dispute with this caretaker, always the caretaker agreement will protect you. So it is a very crucial thing, you need to do it, and I would recommend appointing a caretaker definitely. Yeah.
Absolutely. Ms. Priyanka is stating that what are the formalities involved in transferring property from a deceased NRI's name to the legal heirs? How can NRIs ensure that they receive timely updates on changes in Indian regulations affecting their assets? Can you help me, please?
I'll take this question, Akriti.
Okay.
Thank you, Priyanka Kapoor, for your question. Okay, so you're talking about the formalities. If you are claiming the deceased assets, it can be claimed in two ways. If you have a will, or if you don't have a will, then through natural succession. When you have a will in picture, what you need to do is prepare an application stating that you have a will in your favor, the testator had given the property in your favor. Then move this application along with the certified will or the original will in the office of the revenue department. The department will check the particulars and everything, their records, your records, and then they may ask for the no objection certificates or any affidavits from any other legal heir or interested parties. So if this is the case, if you provide all the NOCs and every other document that is being asked by the revenue department, then the department will do the needful, and the property will be transferred in your name on the basis of the will. This picture I'm talking about only if the will is undisputed. If any legal heir is disputing this will, then in no way you can get this will executed in the revenue department. You need to approach the civil courts, and only the civil court will declare you as the beneficiary and your entitlement on this property on the basis of the will. Now, second scenario, if there is no will and you are claiming the assets of the deceased on the basis of natural succession, again you need to prepare an application where all the legal heirs, particulars of all legal heirs will be mentioned, and you'll state that because this person has expired, we are all the class 1 legal heirs and we are entitled to get his property on the basis of natural succession. Again, this process will be followed. The department may ask any document from you. Once every document is on record, the department will do the transfer on the basis of natural succession. Again, if the department feels that no, the paperwork is not complete, is not up to the mark, and the department is not satisfied with the paperwork produced by you, again you need to approach the civil courts and get the required declaration, and then the court will direct the revenue department to make the necessary changes in the ownership records. I think that answers your question. These are the formalities. Yeah.
I think it was quite detailed for our viewers.
Yeah.
Now, Mr. Karthik is stating that I have come to know that there was a property owned by my great grandfather in Jalandhar, Punjab, and it was huge. But when I searched it online, I did not find anything. I don't know the details of the land, but my friend was telling me that I can find the land on the basis of name and address. Can you help me, please?
I'll take this question. Thank you, Karthik. Okay, so you're saying that your great grandfather had some property in Jalandhar. So you won't find the records online pertaining to this land. What you need to do is you need to approach the revenue department, take out the entire paperwork. You need to dig the information out from the revenue department from last 40-50 years, maybe 70 years. So only then you will be able to figure out what is the chain of events, how the property was acquired by your great grandfather, and how the ownership was changed from time to time in the name of other owners. Only then you can figure out, if you have any right, any claim on this property or not. We offer the service of title search, wherein we prepare the report of the history of the land owned by a particular person, and then we also give a legal advice to the client whether he can claim his right on this land or not. So if you want this service, please let us know. But I think just searching online won't suffice your requirement. You need the entire paperwork in hand, and only then you'll get to know about this land of your great grandfather. I think that answers your query.
Yes. Now we have a query from Mr. Sunil. Aashi madam, for you,
Okay.
NRI Legal Services. In one of the previous videos on buy and sell property in India, you explained the steps and procedures for NRIs in this process. My question is, what if an NRI wishes to sell his agricultural land to other co-owners of which he does not have physical possession? I know possession of the property is a big deal in India, but can it be sold?
First of all, thank you Sunil Kumar for watching our sessions, AMA sessions. Thank you so much. As far as your query is concerned, you can put your property on sale. That is no problem. Yes, obviously having a physical possession of the property is one of the criterias when you put the property on sale, but it's an agricultural land, and if the property is free from all kind of disputes, nobody is illegally cultivating the land, if there is no problems like this, you can definitely put it on sale and you will find good buyers for your property. That is not going to be any problem for you. If it is a partition property, if it is a partition land, then though you will get good offers definitely. So there is no problem. You can proceed with the sale. Thank you.
Now we have question from Miss Mansi. Can daughters also claim rights on the properties left behind by their ancestors? I'll take up this question. Your answer to your question is yes, because as per the Amendment Act of 2005, the daughters have equal rights as of a son. This is very important for all the viewers because when this Amendment Act was passed, it specifically stated that as today on, before or after this act, daughters have equal right, liabilities and share in the property of their father, which is inherited by son. Similarly, it will be inherited by the daughters. I would also like to add on here that even after the death of a co-partner, the daughter also becomes a co-partner of the property, and whether it is a self-acquired property or even an ancestral property, daughters have equal rights in their father's property, and they can definitely claim their share in the properties of their family. And this Amendment Act has actually proven a very boon to the daughters in India.
Yes.
Now we have another query from Mr. Manit. NRI legal team, मेरी query है कि मैंने एक flat में invest किया है and builder is also in touch with me. बिल्डर ने फ्लैट टाइमली डिलीवर नहीं किया एंड इज स्टिल अंडर कंस्ट्रक्शन. बिल्टअप एरिया भी बड़ा हुआ है एंड ही इज आस्किंग फॉर मोर मनी फ्रॉम मी. आई नो ये इलीगल है एंड माई लॉयर फ्रेंड इज सजेस्टिंग मी टू फाइल अ केस. क्या बिना केस किए ये इशू रिजॉल्व हो सकता है?
आई विल टेक दिस क्वेश्चन. थैंक यू फॉर योर क्वेश्चन मिस्टर सूद. जैसे आपने लिखा है बिल्डर के साथ आप कांटेक्ट में हैं, डेफिनेटली यू कैन अरेंज अ मीटिंग विद दिस बिल्डर. Ask him why are these additional costs are being asked from you. You are not bound to pay any additional cost. जो कंस्ट्रक्शन हुई है उसमें बिल्ट अप एरिया बड़ा हो गया है, ये आपका फॉल्ट नहीं है, ये बिल्डर का फॉल्ट है. So if he is asking more money from you, that's actually illegal. So he cannot ask this from you. Have a negotiation with this builder कि आप इस चीज को सेटल करें. अगर वो इस चीज को सेटल नहीं करते हैं, in that case definitely you can give a legal notice to this person. और अगर वो फिर भी इस illegal demand को रखते हैं, you can approach RERA courts और consumer courts. आप अपना complaint put forward कीजिए और definitely आपको इसमें relief मिलेगा, because ये demand जो है वो illegal है. आपका allotment letter sign हुआ होगा definitely builder के साथ, और उसमें जो build up area है और जो उसमें cost है, आपका consideration है, वो उसमें ऑलरेडी लिखा होगा और वो ही फाइनल होता है. तो अगर वो उसके बियॉन्ड जाते हैं, इट्स हिज फॉल्ट एंड कोर्ट जरूर आपको इस चीज में रिलीफ देगा.
Miss Chavi is asking, hi, I want to know whether I should opt for partitioning my co-owned house or should I sell it to other co-owners. I'll take up this query. Miss Chavi, thank you for your query. Please understand, there are two answers to this question, because you're asking that whether I should go for partitioning or sell. When I talk about partitioning a property, you need to understand that partition means separating out your own share from the property. It can be by way of filing a civil suit before the honorable courts in India, so that you have your individual share in the property and then you can transact that share in your own way.
You can enjoy the fruits of the property individually.
Individually. But when I talk about selling the share, since you are already a co-owner in the property, you can transfer your right and share along with the ownership to the other co-owner, so that they can have your part of the share and then they can utilize it in their own way. That means you are giving up your share to the other co-owners. So you have to decide, I would say, that whether you want to give up your share to the other co-owner, or you wish to partition the share in the property so that you can enjoy, as we said, and take its fruits in your own way. You want to utilize it, you want to sell it, dispose it off in your own way, as per your desire. So you need to make sure which option do you need to opt. So that is your answer. And now we have another question from Mr. Gaurav. Thank you for this session. Thank you, Gaurav. We are glad that you are liking our sessions. There is a relinquishment deed in the picture, and it can be relied upon for claiming the right. So Mr. Gaurav, I think it's the question is a bit incomplete for me. It sounds a little incomplete, but I'll answer it. First of all, what is a relinquishment deed? Relinquishment deed is releasing your share, as I said, in a property to the other co-owner. You are already an existing owner in the property. So if you want to claim any right, if you have executed a valid, as per the state norms, a valid release deed which is properly signed by the signatories, executed in the department and submitted in the records, and the mutation has also occurred which states that this part has already been released by so and so party in the favor of another party, then obviously you have a valid claim over that part of the property. But in case there is no such release deed in picture, you cannot claim that share. So it depends which document has been executed or yet to be executed for that part of the property, whether it is agriculture or even a house. So
Miss White is writing something, need an appointment for a one-on-one legal advice for my matter. How can I contact your firm? You can write your query at query@nrilegalservices.com, and we'll have a meeting scheduled for you, and then we'll discuss your matter in detail. I think there are no more questions.
think there are no more questions, but I'll just refresh it once so that I can check if there are any. I think we are done.
So viewers, I think that's it. So I hope you found this this session informative and beneficial. So we will be back with another Ask Me Anything session next month with a new topic. You will be coming to know about that topic very, very soon. So I think it's time to take off.
And I'll add on here that please like, share and comment on this session, AMA Lives. And if you don't want to miss on to such sessions in future, please follow our page on Facebook as well. In case of any queries, please write us at query@nrilegalservices.com, as Aashi has mentioned. And thank you for watching.
Thank you so much. Thank you so much.